Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly podcast show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the founder and former practice group leader for 25 years, and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm delighted to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be discussing today, don't forget about our blog, consumerfinancemonitor.com. We've hosted the blog since 2011, so there's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on whatever platform you may be using today. And also, please let us know if you have ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. So today, we're going to be discussing what I consider to be an absolutely fascinating and a very timely paper entitled Agentic Commerce Needs Legal Infrastructure, and the Courts Are Coming. And it's written by Bridget McCormick and David Hoffman. And it was published on April 22nd of this year, and it's available to everybody on AAA's website. That's the American Arbitration Association. And in just a couple of minutes, you'll find out why it's there. So the article addresses a subject that's rapidly moving from theory to reality: the increasing use of autonomous AI agents to conduct commercial transactions with little or no human involvement, often referred to as agentic AI. The authors argue that while enormous investments are being made in agentic commerce, far less attention is being paid to the legal infrastructure that's necessary to support it. As a result of that, they predict the courts, regulators, and litigants will soon be grappling with disputes generated by machine-scale transactions under legal doctrines originally designed for human actors and not for machines that act autonomously. Our podcast today is closely related to a podcast show we released on May 21 of this year entitled AI Liability Comes into Focus, and it was a conversation with Mark Geistfeld, the reporter on ALI's, American Law Institute's Civil Liability Principles Project. My discussion with Mark explored one of the most consequential emerging legal issues in the AI era, and that is how traditional tort law doctrines, including duty, reasonable care, causation, foreseeability, product liability, and allocation of responsibility, should apply to AI systems. On our podcast today, we are very fortunate to be joined by the authors of the paper themselves. First, it's my pleasure to introduce to you Bridget McCormick. Bridget is president and CEO of the American Arbitration Association International Center for Dispute Resolution. I think from now on, I'll just refer to that as AAA. At least that's how I've always known it. Bridget is leading the organization's global mission to expand access to fair, efficient dispute resolution through innovation and technology. Bridget is a nationally recognized leader on AI and legal innovation. She brings a forward-looking vision focused on human-centered design, accountability, and trust in the rule of law. Before joining AAA, she served as Chief Justice of the Michigan Supreme Court, where she pioneered statewide online dispute resolution and technology-driven reforms to improve access to justice. A very warm welcome to you, Bridget.
Thanks for having me. I'm excited to be here.
Okay, and our next guest is a repeat guest. He's been on one other podcast show with us not too long ago, and that is David Hoffman, who is the co-author with Bridget of the article. David is the William A. Schneider Professor of Law at the University of Pennsylvania, Carey Law School, and one of the country's leading scholars on contract law. David, as I said, has previously been a guest on our show. So, David, welcome back. Delighted to have you back on our program.
Great to be back. Thanks. Looking forward to the conversation.
Okay. Well, I found your article very interesting, although it's very comprehensible and it's very short, which is good, unlike most law review articles that are very, very long. So we're going to do some level setting here, Bridget. And my opening question is that for listeners who may be hearing for the first time, what exactly is agentic commerce? And why do you believe it's arriving faster than many lawyers and business leaders appreciate?
Yeah, and first of all, just to be clear, it's not that this piece was not published in a law review, so it's not a law review article per se, and I am with you on short over long. I like people to be able to read all the way to the end, and so I take the compliment that it's shorter than a typical law review article.
And without a ton of footnotes.
Yes, yeah. I did spend 15 plus years on a law faculty, so I speak with love about my friends and colleagues. So agentic commerce in I think the plainest terms is what happens when an AI agent is doing more than assisting a human with transaction tasks. It's not just drafting an email for a person to send, it's negotiating the terms, the places and placing an order, authorizing a payment, triggering whatever obligations are triggered without a human reviewing those specifics of the deal at all. So it's really a shift from an agent as a tool to an agent as an actor. Humans might set, or probably do set, the policy and the budget, and their agents execute against counterparties a human never interacts with. Why is it developing faster than I think people think? I should say certainly faster than I think a lot of the legal industry thinks. Business leaders are probably divide between those that are involved in this quickly growing market and those that are not. And I think those that are well aware of how quickly it's developing, and those that are not, probably not. But the plumbing for the market is standardizing right now. In the last year, the major platforms have shipped open commerce and payment protocols, including some from Stripe and OpenAI, from Google and Shopify, from Coinbase, Visa, MasterCard. They've all shipped protocols that standardize both how agents can interact with each other and how payments happen in agent-to-agent transactions. And there are businesses that are using agents for negotiating and closing agreements at scale already. In 2025, Walmart used AI negotiation agents to negotiate and close supplier agreements. in a significant number of their supplier contracts. So it's quickly moving, and the forecasts are quite bullish that will continue. I think Gartner projected that by 2028, most B2B buying will be agent intermediated, which isn't to say fully agent to agent, but even if the precise number is debatable, the direction, I think, is not. And the point is that the infrastructure for this market is being constructed right now. And our concern, I've been using Dave as my tutor in this set of topics because he's the expert, he's the scholar, that lawyers are not necessarily in the room as the infrastructure is being built. So that's what caused us to write the article, and I think that's the answer to your question.
Yeah, that does answer very well. So, David, traditional e-commerce depends heavily on the notion of human assent. Clickwrap agreements, browsing notice, payment confirmations, and transaction records. Why do those concepts become unstable when the clicker is an autonomous machine rather than a person?
So I think that the first generation of agents, you can think of them sort of deterministic. So the programming said, here are the conditions under which you can enter into the transaction. And I think law had essentially no problem incorporating those agents into the day-to-day work deciding cases because the human ultimately had a set of instructions which are being executed more or less down a chain that was easy to verify and easy to sort of ex ante and ex post predict. That's just not going to be true, of course, with sort of this new generation of agents where there's just not deterministic connections between the inputs and the outputs. And that produces like two kinds of problems for law. One of them is more easily solvable than the next. So the more easily solvable one is there's all kinds of rules that we have that seem to be keyed on a human looking at the thing. So conspicuous sort of disclosures having effects on warranty. Now, why is that true that like having all caps have some effect on our warranty rules? Because the theory is that some human would look at it and it would change the thing in their brain, and it might therefore be fair or less fair to have the warranty be disclaimed. That set of rules, I mean, that's like a trivial problem, but it is a problem for law. So the short-term thing is what to do about how to interact this sort of set of like notice rules. And the same is true for how conspicuous the font should be in order to get you to be in a deal for a click I agree clause. The courts have spent an enormous amount of time really thinking about font and placement on the page, and all of those rules sort of have the assumption that it would matter, and that's just not true. Now, that's easy, I think. The longer term problem is that like at a foundational level, the core mechanics of contract law assume that there is some human agency that essentially is driving the deal at some level of specificity so that you can therefore sort of say someone consented to this. Now, that has effects on interpretation doctrine. Like, what do they mean when they agreed to the thing? How far does it go? What happens when the text of the contract sort of gets in the way of or differs from the real deal? All of those questions assume a human in the loop. And when that's no longer true, I think we're a little bit unmoored about how to sort of solve them from a traditional common law contracts perspective, which isn't to say we can't figure it out. It's not to say we're not going to use analogies. That's what courts do. That's what lawyers do. That's what we've been trained to do for as long as we're going to continue to be allowed to make decisions. I think we're going to be making them analogically, but they're very challenging problems to think about, to predict, and to make sure the commerce runs in a predictable way. As Bridget said, this is where things are moving. The law is going to follow. It always has for every technological development we've had so far in the last, the 250-year history of the country. And before that, the English common law system, the law has always followed technology, and it will here as well.
Right. So one of the most striking parts of your article, David, is the discussion of ratification. Explain how a company might become bound to thousands of problematic contracts simply by accepting goods or services that were procured by its AI agent.
Great. So let's just sort of imagine that you have your agent with some set of instructions, and those instructions have, let's just say, which is obviously going to be the case some of the time, some lack of precision about a particular state of the world. You didn't quite specify what happens if X occurs in the world. And your agent goes and makes purchase decisions nonetheless. What next? So what Richard and I sort of thought about was like, how does the law of ratification and agency affect that? And the answer is essentially that principals can be bound to agents' actions if they ship the goods or make payment, knowing, or at least possibly knowing, that the terms existed. And the current law of agency is a little bit unclear about how much knowledge the principal has to have of the underlying terms of the contract in order for them to be bound. If they take the goods or services, do they have to like subjectively know? Obviously not. That can't be right. Do they have to like constructively know? Well, what does constructively know mean? And our pitch is, if you are a principal and you knowingly set your agent out in the world, and your agent engages in some sort of contracting, although you might not know the details because there's thousands of deals, and then you conclude the bargain by shipping or paying, I think my view is courts are likely to hold you to those bargains, even though each individual one you didn't sign off on yourself. Now, you might then say, like, businesses knowing this, well, what are they going to do? They might try through terms to control their own liability. And the law of agency makes it a little hard to use internal terms to control sort of the innocent buyer's legal risk. Like, it's just harder than you think. You can't just say, if you go into sort of a store and the store is actually a franchise, you can't, as the franchisor, always slough off all liability by having a sign that says that this particular franchisee is not, my agent. That doesn't work. And because the law of agency has this sort of third-party protective effect. And I think our pitch is this ratification doctrine is likely the one that plays more important role going forward than it has historically, in part because ratification, at least plausibly, requires merely constructive knowledge as opposed to actual knowledge.
Okay. Thank you, David. Let's now turn to a different related topic, but some different issues. And this is dispute resolution and litigation risk. And my first question for you, Bridget, is you emphasize that when something goes wrong, today's systems often lack a meaningful dispute resolution layer. Why is that so significant?
So commerce is, a full life cycle: negotiation, agreement, performance, and then recourse when something goes wrong or if it goes wrong. And the industries building this new market have built the connectivity and payment layers for agents, but they haven't built in a way for those agents to find and record the legal infrastructure that would enforce the agreements that they start making or they are making. An agreement, of course, is only as valuable as the recourse behind it. So without a findable or obvious or agreed to dispute resolution layer, terms and suggestions, terms are just kind of suggestions. And it's my view that agentic commerce strips a lot of the traditional e-commerce recourse mechanisms away. And that's especially true when it's happening on irreversible payment rails, which is how it's happening. And it adds the problem of machine speed and machine volume. So when the recourse layer is missing from a transaction, every failure has to find its way into a court or some other ad hoc process. And you know how that goes. The fighting about what even happened can take as long as the rest of the process. And the gap in the market right now is structural. It's nobody owns it yet. There's not an owner of the legal context and how the agents will find it, how they'll record it in one sort of single source of truth in the event that a judge or an arbitrator or a mediator has to help the parties sort out that dispute. Right now, that's not solved.
Right. So you predict in your article that machine scale litigation arriving from machine scale transactions. You paint a picture for our listeners. What might be the first type of class action or mass dispute could be? What do you think it would look like?
Yeah, I mean, obviously this assumes that none of this gets solved, and I'm spending a lot of time on working on a legal context protocol. So there's hope that the industry can get in front of how to solve this. But to paint the picture you're asking about, I think what you might see is one particular cause with many identical injuries. So a single misspecified policy, or one model or prompt update, or one compromised tool or API credential that gets replicated across thousands or millions of transactions, even if they're very low cost ones, before anyone notices, right? It's just a long time before anyone sees it. And I think probably we're likely to see it on the consumer side first, B2C cases before B2B cases. An agent's going to systematically procure on wrong terms or bad terms or mischarges, or buy non-conforming goods at a scale that's a ready-made class. And there will be legal theories to apply to that series of transactions that's gone wrong. I think you'll see it in B2B transactions as well. There will be systemic defect events. You can imagine a procurement agent or a marketplace integration that just misfires across an entire supplier base and produces a large number of high value parallel disputes that look more like a mass claim than a single case before anybody notices it. Monday morning you come in and you find just a massive amount of parallel disputes. And the fact that a lot of the payment rail disputes are going to be happening on irreversible rails, right? There's no possibility for chargeback or the other ways to absorb the loss. That's going to make it even more complicated. The argument, the dispute has to go somewhere straight to a forum to resolve it. There's no sort of intermediate step to resolve the dispute. And that's going to mean that hard procedural questions are going to follow. Who's in the class? Where are the records that show whose agents' instructions governed? How do you figure out how to run a bellwether class when every transaction is machine native? I mean, it feels like it makes my brain hurt to think about it, honestly.
Couldn't you deal with the mass action thing is, I think more complicated, but with respect to a true class action that got filed in court, wouldn't you be able to enforce a class action waiver in a contract and therefore require whoever the named plaintiff is to litigate, to arbitrate on an individual basis?
That assumes that the agent that negotiated and executed the contract consented to that waiver and has a record that can prove it, a single source of truth, that it's somehow found a way to make a record of that waiver agreement provable and non-contestable. And right now, there's not a way to do that. I mean, there could be. This is fixable, but right now, you wouldn't have a single source of truth about what was agreed to in terms of any waiver.
Right. Got it. So you also describe in your article so-called liability cascades, where buyers, sellers, platforms, model providers, API vendors, and payment processors all get sued. Why is that ecosystem-wide exposure so dangerous?
Yeah, it's just a significantly more complex cast of potential parties, right? Any single agentic transaction is going to implicate the buying enterprise, the selling enterprise, the platform or the marketplace, the agent provider. Most businesses are not building their own, procurement agents. They're buying them from another service. the model provider that the transaction's happening on, the API vendors, and then the payment processor or payment rails are going to be a completely different party. I think when something goes wrong and there's no single source of truth about what went wrong and what was agreed to, it is going to make sense for a plaintiff to name all of those potential parties, because at filing time, it's going to be hard to know where exactly things went wrong. So who caused the loss? And I assume every potential defendant is going to point fingers at the others. And the delegation chain is just long and right now undocumented and without a record of who authorized what and who set which parameters or constraints, what each agent actually did. There's not really a clear answer for allocating responsibility. So everyone's going to carry exposure and everyone's going to get the game is my guess.
Okay, thank you, Bridget. Going to go back to you now, David, and we're going to talk about cross-border and choice of law issues. Agentic commerce will often be borderless. If an AI agent in New York contracts with the seller in Europe through an infrastructure hosted elsewhere, this sounds like a law exam question. Whose law governs?
So a couple things. One of them is I don't teach conflicts of law, so I'm glad not to either offer that exam or take it. The second thing I'd say is, of course, the agent's not contracting from anywhere. It's not contracting from Ireland. It's not talking to California. It's not going through Europe. It's all, there was a person. The person delegated some set of authority to a computer program. The computer program is, of course, hosted in all kinds of places and no places at once. And the answer is, where is the lawsuit brought? Because the lawsuit's situs determines the choice of law in that place. The choice of law, of course, is different in different places. Different real courts have different views about how to engage in choice of law. Those courts can have conflicting methods by which we sort of decide what law governs. The easy answer would be that the parties agree to a choice of law clause, which of course, many of them will, although, as Bridget says, getting that choice of law clause reduced to a form that is provable ex post requires some work. I mean, that's going to require some infrastructure work to allow parties to opt in stable ways to choice of law clauses. And my guess is most of the time people are going to want to choose New York law because they think it's predictable. I mean, that's just like how the world offline has worked. And so it's presumably how it will work in this context as well. But in the absence of a choice of law clause, it's just where you get to court first and get the majority of parties sort of in some compulsory jurisdiction setting. If you're in non-compulsory jurisdiction, you've got sort of multiple cases in multiple places, you can have different outcomes depending on the choice of law clause. Now, this might be a little overstated because in some ways, like, this isn't torts, right? This is just contract law, at least for the part of this podcast that I understand, which is contract law isn't that different place to place. I mean, it's different in some ways and maybe on the limiting case, but like a lot of the ideas are pretty similar and the scope of liability isn't particularly different, at least within the US and within the Anglo system, Anglo-American, but England and here as well. But you could have real confusion. And so that's why you really do need a way to credibly commit to a choice of law clause and have that choice of law clause bind the parties, because or else it's a mess.
Yeah, I get it. Okay, now I'm going to go back to you, Bridget. If you were advising a board of directors or a general counsel of a company today, what immediate steps would you recommend before deploying an autonomous commercial agent?
Yeah, it's such an important question. I mean, especially given how quickly the market's developing, and I think the pressure on businesses to show they are, AI forward and moving with this market. I think there's a lot you can do internally. You can scope and document. If you're using agents to transact for you, you can scope and document the authority of those agents in writing. You can have explicit spend limits and category limits and counterparty limits and and then and also the conditions under which they may bind the company. Not saying that all of that will hold up, but you want to do all that, obviously. You want to build evidence preservation in from day one. I'll say in a minute that it's probably not good enough to only build it in on your side, but it's a good place to start. You want durable and tamper-proof logs of what the agent was authorized to do, what actually happened, what it negotiated, what it agreed upon. I think you want to require an agreement record for transactions that are consequential, meaningful, like a provable record of parties, of terms, of, as Dave said, the governing law at the time of consent, not just the payment receipt. And there are ways to do that to hash those terms so that there's no debate about it later. I think you want to pre-negotiate dispute resolution and obviously governing law and bind that at the formation rather than trying to fix it after the failure. And those are the kinds of things that a protocol that governed the legal context could do. And I think the industry is going to organize around that, which will be helpful. I think you can put a human approval gate and a kill switch around high dollar or high value or high risk actions, right? There should be some actions that your agent just has to send back to you and may never do on its own. I think you should talk to your carriers. I've seen stories just in the last couple of days of carriers backing away from covering some of the indeterminacy in agentic processes in some industries. So I think I might want to check in with my insurers. And I think on anything consumer facing, you want to really run your legal traps to make sure that you're satisfied that it will pass any consumer protection review. That's a lot, but that's a start.
Yeah, that is a lot, and the problem is you don't know exactly that it's all going to work. You could have you might think you have a great infrastructure that you've created, but you may ultimately find out that something didn't work right?
You might, which is why obviously the more this is worked out at the front end and worked out at the front end across stakeholders in the market, the better.
Yeah. So let's talk about AAA for a minute. The organization that you run as CEO. What kind of role can AAA play in creating scalable dispute resolution mechanisms for the new economy?
Yeah, I appreciate the question. This is actually how I got started in this rabbit hole that I'm not sure I really belong in, but here I am. I was just following how quickly the market was moving, and I'm always trying to make sure that we have panelists who will be able to be good choices for parties who have disputes in new areas, new dispute types, here entirely new market, which seemed to me was going to take some recruiting. Happy to say we recruited Dave Hoffman to that panel, but I knew we needed to make sure we had the right people for disputes. And that's when I started peeling back the onion and decided that I thought there were some more fundamental problems that needed to be resolved, even though when disputes arrive, I do think folks will be able to be confident that the AAA will have a really top-notch panel to be able to manage those. So that's one thing. I do think that the institutions that have kind of built trust infrastructure over decades, or in the case of the AAA, over a century, are going to be helpful in figuring out how to navigate disputes in this market, and so they will be integral to it. And so we intend to be. We've been building a lot of products and services with AI ourselves, and have built a number of agents that work across some of our AI arbitration products, and we will be prepared to have all of the terms of our services and offerings available for agents to read and understand if they want to include those in a transaction. I think the AAA is in a position to scale with the market in a way that's hard for many other institutions to do, and to sort of tier resolution options to the value at stake. You could imagine fast, low cost, largely automated paths for kind of high volume, low value exceptions, and escalating from there to, more complex dispute resolution with expert neutrals that we will be continuing to make sure we have on hand, so that at least folks in the market feel like they can work through these hard problems as they come, because they will come. But being discoverable to agents is going to be pretty important, and that means you have to be able to make sure you have an agentic kind of front door for agents to kind of come through and see what you have. And that's something we're able to build. We're lucky to have a big enough team and a talented enough team to be able to put a lot of it into place. But we're excited to make sure that the market has good choices and good options so that contracts are enforceable. And
have you had experience already? I mean, you're talking about what you're building for the future, but have there not been any disputes that have arisen already in this context of autonomous decision making?
Yeah, it's a good question. I don't think I can answer it. We resolve over 500,000 disputes every year, so I don't have my arms around every one of those. But we do have sort of a Web3 smart contracts bespoke panel, and we have that because we see it's coming or know it's coming. But I wouldn't be surprised if there aren't already some of these in the pipeline, because there will be certainly some that will at least try to enforce an arbitration clause, even if there was some problem about whether the agents agreed to an arbitration clause. So,
right, got it. Okay, yeah. Well, David, have you served on a panel yet, or you're waiting?
I have not served on a panel yet. I'm looking forward to it. It'll be fun.
Yeah, I'm just wondering, when you have a panel, whether there's a need for not only a lawyer to be on that panel, somebody who's steeped in the area of contract law like David, but you also need a techie on the panel, somebody that really understands how these robots are created.
it's interesting. There is a little bit of a gap in the legal profession, especially in the senior members of the profession who are, Dave excluded, he's very young still, but who are normally serving as arbitrators are not always necessarily fully conversant in AI technology. But you'd be surprised. There are some out there, and they're on the list. But you're right. We have recruited in other dispute types, like, for example, in complex construction disputes, we have engineers on the panel, and sometimes that's who parties want. They want somebody who they know is going to really understand the technical part of the problem, not just the legal question. So, yeah,
I can definitely confirm that, because AAA arbitration that I served on that involved a so-called construction defect, and the question was the architect at fault or the contractor at fault? Thank goodness our panel was not all lawyers. In fact, I was the only lawyer on there, because a lot of the lingo, you need people that are steeped in that area. So let's look ahead, and I've got a few questions for both of you. Do you expect that legislatures eventually will end up modernizing agency and contract law for AI systems, or will the common law evolve first through judges deciding cases one at a time? And of course, we're assuming here that arbitration is not involved, that these cases end up in court. And David, let me throw that one out to you.
So, I mean, the UN actually has a model law on AI contracting. I don't remember the name of the law, from 2024. And I do think that you could see NGO organizations, the AOI, which you talked about in your recent podcast, the sort of uniform commission, work on model codes to the extent that they see problems that need solving. The question of whether legislatures are going to proactively get involved here. I guess my view, although I've got lots of enduring faith in the power of this country to figure things out, is that like right now it's really hard to do national level legislation on any topic, let alone ones that sort of are going to touch so much to the core of the American economy. I think it's really hard to do. So my guess is that we'll do what we've always done, which is sort of muddle along, discover problems, have decision makers try to solve them. I would just push back a little bit, which is I think that the arbitration, whether it's in the AAA or not, court arbitration hybrids like Singapore have, and court systems are all producers of something we could call like the common law, which is just like a record of decisions that try to solve problems in iterated stepwise ways over time. And I just think that's what we're going to do for a while. Now, at some point, there might be too much dissensus between those decisions, or the relevant stakeholders think that the decision makers have gotten it wrong. And then they'll run to their governing sovereigns and they'll say, we need a law that fixes this set of problems for us or for all time. And like that's kind of how this country has made law in commercial spaces generally. And that's what I think will happen going forward. I don't see in any short-term vision of the future, like the US Congress or California or New York, like, well, I mean, I would love for them to call Bridget and say, what is the law and what should we do? But like, just generally, that just seems really unlikely. What seems like a better thing that will more likely happen is we will, in individual level tribunals, try to get to sensible answers based on some analogical process to what we did yesterday. And that might be wrong. And if it is, then we'll see law in the sort of the delivered way.
Yeah. So I referred in my introductory remarks, I'm directing this to you, Bridget, about the ALI project that the Columbia law professor Geistfeld is currently the reporter of, that they're putting together not a restatement of the law, but a principles project entitled Civil Liability for Artificial Intelligence. And they're dealing with tort law. They're not dealing with contract law for sure. Do you think any of the work that they're doing, and I think it's very much in the early stages, I have no idea when they're going to be finished, will be helpful in clarifying some type of liability for agentic AI? And I guess what I'm saying is, apart, because they're not going to deal with contract law, is there tort liability in this area that needs to be dealt with?
Yeah, well, first, it's a principles project because there's no law yet, right? Like that's why it's not a restatement. I think it'll take a while for us to have a restatement. I'm on the ALI Council, but its center of gravity is like tort and all the tort doctrines, duty, reasonable care, and how to allocate responsibilities when AI systems cause harm. And I think that's genuinely useful for one corner of this story that we're talking about today, the model and product defect part that we talked about, the liability cascade, where there will be allocation among different parties, and there'll be question about who harmed who, and it'll be a tort question. But I think the core of agentic commerce is agency and contract. So it's who's bound. Who was the agent authorized? Did the principal ratify? What are the terms? And those are really not tort questions. And so I think it's going to be helpful and adjacent, but not exactly the answer to the questions.
There is correct me if I'm wrong, but I think there's a restatement of agency law, right? Yeah. So could ALI play a role by starting a new project to either revise that restatement, come up with another edition, or come up with some special thing that would apply to agentic AI? Similar to what they did recently in a case where I was on the board of advisors, where they created a restatement on consumer law as something that's an adjunct to an existing restatement. I'm just wondering, either of you, if you think that is something that might bear fruit.
I think the ALI is better poised than anybody else to put something like that together. The process the ALI works under is, as you know, very deliberate, and which could also be described as slow for a reason. There's like a reason why we want they recruit the best scholars as reporters, then they let the ALI council beat up the reporters over and over again at many meetings. Not beat up, it's good questions.
Yeah, it took 9 years for this statement of consumer contracts.
So that's my
beginning to end.
So that's my main concern. I mean, I don't know if the ALI could move quickly enough given the way it works. And I think the way it works is pretty important to what it puts out, that it could produce something soon enough to be helpful. I do think the ALI's role in its next century, it's also a century old, is something that I know that we're thinking about at the council level, because I've been thinking a lot about how you want to make sure agents have a way to read the restatements, right? The ALI needs its own MCP server for agents to be able to come find its products. But I don't know that it can produce a new one quickly enough to make this set of problems go away. But Dave might disagree with me.
I think the ALI is an immensely important organization that produces a product that is foundational to lots of what we do as lawyers. The success of that product turns on there being law first. So putting aside the mechanism and the slowness of the production, all of which you could describe either as a feature or a bug of the restatement production process, it's a restatement. Even the principles projects are principles generated from case law. And so if what sort of is the idea here is let's look forward and try to engage in some sort of policy making about what the thing ought to look like, that might be something the ALI can do because it has convening power and it's an amazing organization and has lots of folks who care about its mission. I'm one of them. But the thing that it would do would neither be a principles project nor a restatement. And whether that has the gravity, the reason why it's successful is because people want to listen to it. Whether it can create a product that people want to listen, that convenes people around a table, the right stakeholders with the right answers, I don't know. ALI suffers from the same problem that I think we all suffer from as a part of this society, which is trust. How do you build trust that you are sort of a person with integrity and the organization with integrity? And what Bridget said, which is right, is organizations that have built trust over time, ALI is one of them. I think the AAA is another one of them. The American court system is a third. Are going to have to find some way to spend that currency in ways that are socially useful so they're not just hoarding it. I don't know that the way is a restatement project. If you look, Alan, I was also involved in the restatement of consumer contracts. I wouldn't say that was a super smooth sailing situation. And I do think that part of the criticism, the reporters who were my friends, who I supported, and I agree with the ultimate conclusions of that, was they were ahead of the case law, well ahead of the case law. And they got beaten up, not just by the council, but by everyone on both sides of every single political spectrum. So I just would worry about putting my friends in the situation of saying, go solve agentic commerce with no case law to go forward on. That's my reaction to that.
Yeah, no, I hear you. So here's another very difficult question, and that is, I'm going to ask you to project where things are likely to be in about 5 years. What will surprise us more at the end of 5 years? How quickly agentic commerce scaled, or how expensive the first wave of legal disputes became?
I think that the scaling is already a consensus story where everybody's already, watching that curve and talking about it. The stablecoin market is what is it? It was 30, I think roughly $33 trillion in 2025 of stablecoin gross transfer. That's of course also includes, treasury activity, not just payments, but even if the payment slice is smaller, it's still, I think, a few $100 billion. So I think anybody who's paying attention has adjusted to how quickly the market is moving and scaling. But I don't think we have fully thought through what the legal ramifications might be of a market moving that quickly without a front end legal infrastructure built into it. So I think I go with cost of getting the legal infrastructure worked out will surprise us a little more in 5 years. But I don't know. I don't think our brains fully understand exponential change. So I don't know.
Do you agree, David?
I mean, I agree that our brains don't understand exponential change, and I'm one of those brains. So I don't know anything. I will say that in 2020, when we were engaged in like the great pause after COVID, I thought, oh my God, this is going to be the biggest litigation event that there ever has been. There's going to be more contract messed up because we are waiting for 2 months to deliver anything. Then in the 200-year history of the country, this is going to be it. And there were like 8 cases. I mean, not 8, but like within an order of magnitude of 8. And that just like taught me something about like the natural resiliency of the American sort of commercial system and the willingness of people to behave reasonably in the face of evulsive change to sort of work through problems without recourse to formal decision makers. So I'm going to go with door one. Like, we're going to be surprised by how transformative this was for business, and the dispute resolution thing will be important. For lawyers, I hope a way for us to show value. For decision makers, a way for us to show that we can use analogical thinking in useful ways, but not probably, I think, as challenging as the scale of the optimistic version of the case would make us worry. Now, I could be really wrong about that, but like I did write a whole article in 2020 that's like, well, now we're going to finally have some contract cases, and then we didn't. So,
yeah. Bridget, you mentioned stablecoin, and actually came up earlier in our discussion when you raised the nightmare of transactions being irreversible. So if commerce is increasingly moving to crypto or stablecoin payment rails that are irreversible, does that eliminate the private remedies, the chargebacks, the reversals, the network arbitration that helps stabilize e-commerce?
Well, it certainly eliminates the e-commerce solutions like chargeback and reversal, and it just underscores the need to get your dispute resolution process right at the front end. You're not going to have those not informal, sometimes formal, but sort of intermediate steps and processes that can operate to solve a lot of problems before they escalate. So irreversible rails are not bad, but when you remove the automatic undo, you just have to put the recourse back in deliberately. It just makes it more important. That's all.
Yeah. So we've come to the end of our program, but let me just, before we wrap it up completely, do either of you is there anything about that was in your article that we failed to touch on that you can think of, or anything else that you want to say on the subject, either you, Bridget, or you, David? No? Okay. So this is, I think, Bridget and David, this has been an extraordinarily thought-provoking discussion. At least I found it that way. Your article highlights that the challenge is not whether autonomous agents will participate in commerce. They're already there. There's nothing we can do to stop the technology. But whether the legal architecture necessary to support that commerce will be built deliberately, or whether it will emerge through litigation or regulatory enforcement. Thank you both for joining us today and for sharing your insights. And thanks to our listeners for tuning in. We hope you found this discussion as enlightening as we did. And be sure to subscribe to our podcast and join us again for future episodes. Thank you.